we're going to continue the discussion that we did on our TV show. I want to ask you the more broad question. Does a juvenile, a child who is accused of a crime, looks like he's been arrested or looks like maybe he's going to be arrested, does he need a lawyer? And if he needs a lawyer, she need a lawyer? And if so, when do you get a lawyer? Let's say you're the parent or the guardian.
Absolutely needs a lawyer.
Okay.
Absolutely. In fact, the law requires it.
Okay. Oh, the law requires it.
Yes.
And if they need a lawyer, when do they need a lawyer? At what point do they get a lawyer? And frankly, how does someone afford a lawyer? I know lawyers often charge a lot of money.
If they can't afford a lawyer, they can use a public defender's office. The public defender's office in Orleans, Jefferson Parish, all the lawyers are very competent.
Competent meaning they can do their job.
They can do their job. They can do their job.
Okay.
There's good supervision in both of those parishes. Now, what lawyer you get, it changes from day to day, so I cannot tell you. If you don't feel comfortable with that lawyer, hire a private attorney.
Okay.
Find the money.
Right.
It's important for your child.
Why would you hire a private attorney if you got competent lawyers in the public defender's office?
Well, if you're confident, comfortable with your lawyer, then it's not necessary. If you're not, or if it's a serious case and you are concerned about the experience that particular lawyer has, hire a private lawyer.
Okay. And what are the, let's talk about that, pros and cons of a public defender versus a private practice attorney. A private practice attorney is somebody who maybe they've been doing it a long time, maybe they've been out of law school for a year or two. I guess depending on the private practice attorney, that could tell you if it's a pro or a con right there. Why don't you explain?
Well, first you need a lawyer with criminal experience, because what we're dealing with are criminal statutes, right? You also need a lawyer who understands juvenile law and has juvenile law experience, because there are differences, because we are talking about adolescent development of children. There has been a push in some areas of the country to have a special certification for juvenile lawyers. We do not have that in Louisiana. So if you're looking for a lawyer, you want to use the internet, you want to use whatever referrals you have to get a lawyer who's not just has criminal experience, but also has juvenile experience.
Right. So if I'm understanding you, let's go back to that first question. Does a child need a lawyer if charged with a juvenile offense? And when? The answer is yes. A child definitely needs a lawyer if charged with a crime. In fact, they're required to have one. And when is from the get-go, right away?
When it will be when they're brought to court for their continued custody hearing, a lawyer will be appointed for them.
Okay.
Okay. If you should hire a lawyer before you let your child give any statement to the police. It should be do not give a statement and then hope that they're just going to let it go away. That's not their job. Their job is, if they take a statement, if there's evidence, your child will be arrested.
Typically, are the police going to be trying to interview the child before that first court hearing?
Yes,
okay.
They will.
So even if you don't have a lawyer for your child, can you insist that the child not be interviewed, or insist that the child have a lawyer and let the lawyer decide about an interview before the interview happens?
Yes, a child has all the constitutional rights as an adult with the exception of a jury trial. So you can insist on your Sixth Amendment right to counsel. At any stage of the proceedings, and you should.
Virtually no lawyer is going to allow that child to be interviewed.
No lawyer is going to allow that child to be interviewed. The big problem we have, one of the big problems we have, is adult standards being imposed on children. The criminal statutes are written for an adult. The most egregious example I'll give you is the aggravated rape statute. Aggravated rape, which carries as an adult a life sentence, is having sex with amongst the many things, is having a child under the age of 13. Having sex with a child under the age of 13. What if your child's 12 and he has sex with an 11-year-old child? This has happened. Okay. I mean, I've had this case. They're both under the age of 13. What's the district attorney's office going to do? Charge them both with aggravated rape?
Right. That's crazy.
It's crazy. This is a crazy case. This is a statute written for adults.
Right. Well, what if you're a parent and you say, look, you know what, maybe my kid, this is all a big mistake. Well, let me just go in there. I didn't go to law school, but, you know, it's all a big, my child tells me he didn't do nothing wrong. I'm not a lawyer, but I can go in there and I can speak for my child and we can sort this all out. Is that wise?
No.
Why not?
Your child is going to lie to you because they don't want to get in trouble. All right?
I didn't take the cookie out of the cookie jar. It's just a little bit more advanced.
It's a little more advanced. That wasn't me. They're not going to tell you the truth. But then you have a deputy who is confronting him with years of experience interviewing children. They're going to tell that deputy an entirely different story than they told you, and they're going to land up in detention.
In fact, getting back to an example you gave on the television show, also available on this website, some deputies, if they have convicted themselves in their own mind that the child is guilty, they have ways of interrogation that might get the child to admit to doing a wrong the child never did, correct?
This is a common problem we have in juvenile court, false confessions of juveniles. I gave the example of the Central Park jogger. There's a similar case in
lady
Chicago.
in New York who was beaten so badly she didn't remember what happened. Donald Trump took out ads saying, return the death penalty for juveniles. Later on, after the children were convicted, after they confessed, DNA exculpated them entirely, said they didn't do it at all. The children had their words, they had their heads turned around in interviews, and they said they did it, or they said words that people interpreted as saying they did it. All right, we're running short on time, but go ahead. What were you trying to say? I think I interrupted you.
You had a similar case in Chicago, 5 juveniles arrested for rape and murder. False. The children were saying these were, you know, they were coerced out of me. Again, DNA comes back.
Once they had attorneys get involved later on, the attorneys tried to sort out the mess, but by then a lot of damage had been done.
The other thing, and this is why I'm really insistent on what you think as a parent. This is not serious. As soon as the adult statutes start applying adult circumstances, it becomes serious.
It's adult statutes applied in juvenile court, applied to juveniles, even though it's juvenile penalties, etc.
A kid with a BB gun takes another boy's bicycle. All right, that's bad. I'm not saying it's a good thing. All right.
I probably did that when I was a kid.
But it's,
no, I didn't do that.
But it's not armed robbery.
Still, it's not taking a gun that could kill somebody.
But it is treated as an armed robbery because as an adult it would be treated as an armed robbery, and your child is looking at a mandatory prison sentence.
Right. And maybe the DA is using that just for leverage, so they can get you to admit to agree to a plea deal later on. That's whatever they feel like getting. They get a conviction on their whatever their conviction rates.
Right.